I would like to start today's event by introducing the topic. I'm very happy that today is the first webinar in 2026 dedicated to transitional justice that we continued together with our partners last year. And we had a small delay in the beginning of the year, but now finally we can resume talking about transitional justice, its relevance to Ukraine, and the issues transitional justice has globally. Today's topic is of utmost importance to Ukraine as well, but also to the world. We have a pleasure to hear the report about Russia's predatory recruitment, in particular legal status of Putin foreign fighters and international POWs in Ukrainian captivity. This is the report prepared by the Truth Hounds, and we're very excited to hear more. The series, the series of events on transitional justice. I'm sorry. Was launched jointly by the Ukrainian Bar Association and its Human Rights Institute, the International Center for Transitional Justice, the National University of Kiev Mogila Academy, and the Truth Hounds, respectfully. And I'm very happy and I'm very grateful to our partners for supporting this initiative and for joining efforts in disseminating information about transitional justice and sharing thoughts and suggestions for the Ukrainian context. I would like to remind our audience that previously we held a series of webinars dedicated to various contexts or elements of transitional justice. We started from the conversation with the Special Rapporteur on Transitional Justice, talking about TJ in the context of international armed conflicts, which is a focus in Ukraine. We also organized dedicated webinars discussing the experience of South Africa and Sierra Leone. However, we also discussed certain elements of transitional justice that were particularly hot for Ukraine, and they include, for example, prosecution of international crimes and peace processes, domestic justice and international criminal justice, and others. You can watch the recordings of the previous webinars on the YouTube channel of the Ukrainian Bar Association, and we would be grateful for dissemination of information about these events, recordings, information about any future events, so that we join the group of like-minded individuals. We, together with our partner organizations, we plan to continue this series of events and cover more contexts and more elements of transitional justice. Colombia is one of the next jurisdictions that we wanted to look into in view of its major experience on transitional justice and a lot to share. We also wanted to look into specific contexts of international armed conflicts, such as Indonesia, East Timor, Sudan's, Iraq, Kuwait, to reflect on what has been done in the decades since the conflicts and whether we can draw any lessons for Ukraine. If you, our audience, have any particular thoughts, questions, topics that you think are interesting, please share with us and we will see if we can integrate them into our events. Now I would like to pass the floor to my wonderful co-moderator, Maria Tomak, who's actually the co-author of the report and an advocacy expert with the Truth Hounds Ukraine. My name is Ina Linova. I'm the director of the Human Rights Institute of the Ukrainian Bar Association. Maria, please, the floor is yours.
Thank you so much, Ina. Good afternoon, good evening, good morning, everyone. It's my pleasure to introduce today's panel of outstanding experts, and it will be, I'm sure, very interesting conversation about law, but not only. Before that, I would just briefly say about the report that was mentioned already by Ina. So the report that was jointly prepared by the Truth Hounds, FIDH, and our partners from different parts of the world was presented recently in Kyiv. But after that, and it covers, of course, this issue of foreign fighters that are recruited by Russia. And the complicated legal nature of this phenomenon is reflected in the title of this report. It says combatants, mercenaries, combatants, or human trafficking victims. And that's one of the issues that we would like to discuss today with this audience of professionals in the first place. So we tried to look at the patterns all over the place because Russia is conducting this recruitment all over the place, like throughout the whole so-called global south, various countries and continents, but also to look at the legal definition of this phenomenon. So we presented this report not just in Kyiv, it was presented in Brussels a few times for the audience of experts, but also for the decision makers. But also it was presented in the places where we have never presented anything, like African Commission for Human and People's Rights, which is located in Banjul in the Gambia. And also recently it was presented in Nepal, where the recruitment at some point was very, very intense. So, and we will talk about all of that, but I would like now, of course, to introduce the panel in the alphabetic order. So, Artur Alhasov is with us. He's independent lawyer and co-author of the report from Kazakhstan. And of course, Central Asia is affected, one of the most affected region by the Russia's recruitment. So it would be important to listen about that. We have Dmytro Koval, my wonderful colleague, who is a co-executive director of the Truth Hounds and famous international lawyer in Ukraine. Ilya Nuzov, who was a co-authoring the report and who is the head of East Europe and Central Asian desk at FIDH. And last but not least, Rosemary Tolo, who is joining us from Kenya. She's a Kenyan journalist and she investigates the issue of foreign fighters, recruitment of Kenyan youth to the Russian army via the predatory schemes. So that's it for me for now. And Ina, I give you the floor back to ask the first question. I think the mic is unmuted.
My apologies again. Thank you, Maria. And I would also like to welcome our wonderful panelists. We're very lucky to have you with us and to benefit from your expertise and research into this area. I would like to start with Ilya. Could you please explain to the audience why Truth Hounds and the International Federation for Human Rights come to the conclusion that Russia has created an organized system of predatory recruitment that targets foreigners for its war of aggression in Ukraine? And why does this matter in terms of international law?
Yes, thank you very much, Ina. And thank you, Maria, for the introduction and for the organizers and for those of you from the legal community that are taking an interest in this very important issue. I always say that we didn't start out with the working on this report thinking about predatory recruitment. It was not supposed to be really a human rights report focused on predatory recruitment. We were concerned, of course, with the participation of foreign fighters on Russia's side because, in our estimation, any individual, regardless of their motivation, that ends up fighting on Russia's side in Russia's aggression against Ukraine is somehow enabling, furthering the aggression and occupation of Ukraine. And so it is important to stem entirely, or at least diminish, the flow of foreign fighters on Russia's side. And so in order to do that, we thought that, well, let's look at the legal qualification of these individuals because they're always called mercenaries. Are they actually mercenaries, or are they combatants, or are they something else? so that we can ground recommendations on how to stop the flow of foreign fighters in international law, which is, of course, our mandates, the mandate of our respective organizations. And we wanted to look also at the state responsibility, namely of the state, the recruiting state, Russia, and those states that are providing willingly or not, fighters for participation in the war on Russia's side. So that was our starting point and overall sort of objective. And so we wanted to ascertain the modalities of recruitment, both within and outside of Russia, and then the motivation of fighters, because as you well know, the motivation is a key element in establishing the legal qualification of these persons. So when we started conducting the research, we came to some very surprising, I would say, conclusions, or we found some very interesting and surprising things. So when we started looking in depth about what is happening, the mechanics of recruitment within Russia, we found that Russia has established a normative framework, really a system that is grounded in law to augment the reserve of soldiers, what's called on contract, to replenish the diminishing flow of fighters from mobilization, and to make up for the shortfall of ethnic Russians or Russian nationals who are signing up contracts. It also resorted to targeting foreigners. And both with respect to Russians and foreigners, it has really preyed on those that are the most vulnerable, the poor, those in the precarious social or legal situation. What has it done? What does the system consist of? Well, first of all, Russia made it easier to sign up to serve in the ranks of Russia's armed forces by expanding the pool of eligibility, and namely by relaxing the age, the language, and the legal requirements to join. In other words, whilst before foreigners aged 18 to 30 were able to sign up, now it became possible for foreigners aged between 18 and 63 to sign up. Whilst before some level of Russian was necessary, now that requirement was omitted. Whilst before a legal residence was required for entering into a contract with the Ministry of Defense, this was no longer required. In fact, signing a contract and serving 6 months in the so-called special military operation was now a way to gain Russian citizenship. And if in September 2022, the law on citizenship was changed to allow for eligibility for citizenship after 6 months of service, by May 2023, one became eligible for citizenship immediately upon execution of the contract. So, in addition to making it easier, there's that first incentive that we saw in terms of citizenship for foreigners to sign up. Also, special centers were created to facilitate for migrants the possibility of regularizing their residency status, and at the same time signing a contract for the Ministry of Defense. Moscow's mayor Sobyanin openly declared the establishment of a Sakharovo Center for migrants, which would be a one-stop shop for migrants to regularize their status, and, by the way, sign a contract with the Ministry of Defense. So just showing the intent was already evident early on after the full-scale invasion to target foreigners. Also, there were obviously huge monetary incentives and a budget that was allocated to create financial incentives for fighters to sign up. It's well documented that fighters were offered bonuses of up to several thousand euros, and then monthly payments between 2,000 and 3,500 euros per month. But, and this is a lesser known fact, money was also offered for referrals by state agents or private individuals of potential recruits. And what's interesting here is that some regions of Russia even differentiated between referrals for foreigners coming from near abroad, such as Central Asia, and those coming from far abroad, like Kenya, and offering less money for those that are brought in from near abroad and more money for those recruited from farther away, because obviously the logistics involved in getting somebody from, say, Kenya or the Gambia would be much more challenging than getting somebody to sign up from Central Asia who might already find themselves inside Russia. So in addition to these incentives, enticements, Russia has also sanctioned the use of force, administrative pressure, intimidation, as are interviews with prisoners of war. And I think it's important to mention that the report is based on 16 interviews with the POWs that Truth Hounds has conducted, as well as open source research, which we use to corroborate this information, which shows that the use of coercive practices targeting vulnerable individuals that found themselves already inside of Russia, but also outside, and deception accompanied basically every level of every step of the recruitment process. And I think my colleagues will elaborate on that a little bit more, but so I won't go into details about this, but basically, we saw that there have been false advertisements of civilian opportunities, working opportunities, which then ended up being recruitment for participation in fighting. There have been cases of people being deceived into signing just stacks of documents which contained a contract hidden in that stack. There have been instances of beatings, threats of deportations of migrants in exchange for signing recruitments from prisons under pressure and threats. And almost all of our interviews and many cases that we've encountered in our research, the recruits ended up in what are called meat assaults, being used as essentially cannon fodder to be thrown at Ukrainian positions within several days to several weeks of signing contracts with the Russian armed forces with very, very little training. So what does that all mean? Our main legal conclusions are, with respect to the individual level, we actually don't have a very clear answer, and we're going to get into some of the nitty-gritty of these legal qualifications on the individual level. But basically, we came out that with the conclusion that it's very difficult in international law to qualify someone as a mercenary. And most fighters will be entitled to combatant status. But our central conclusion is that with respect to those fighters that have been subjected to deceit and coercion to the extent that makes their consent to serve in Russia's armed forces meaningless, they could be considered victims of human trafficking. Because they've been recruited and transferred to Ukraine through deceptive or coercive means for the purpose of being used, for lack of better terms, as disposable human material to gain a military advantage on the battlefield. Why does Russia bear responsibility for this practice? Because Russia has an obligation under international law protocol to the UN Convention Against Transnational Organized Crime, so-called Palermo Protocol, to prevent, prosecute, and protect victims of human trafficking. And with respect to thousands of cases, Russia has not only implicitly condoned this practice, it has actually created an institutionalized system of predatory recruitment of vulnerable individuals with the sanctioning of the state. So it has violated its negative obligation to not engage itself in predatory recruitment, as I illustrated, by creating this system, institutionalizing this predatory recruitment system. And it has also violated its positive obligations to prevent, prosecute, and protect victims of human trafficking when it concerns recruitment, particularly outside of Russia, because we didn't have enough facts to show that Russia has actually controlled the recruitment outside of Russia, but it has certainly sanctioned the deceptive and coercive practices outside of Russia if they were conducted by private individuals, because it has facilitated the issuance of visas, It has sometimes even sent invitation letters, for instance, to facilitate the issuance of visas. Sometimes we have indications that the so-called culture houses, Russia culture houses, have been used to recruit individuals, and even embassy staff has been involved in recruitment. So even with respect to what happened outside of Russia vis-à-vis foreigners, we think that Russia is responsible for failure to uphold its positive obligations to prevent, prosecute, and protect victims of human trafficking. Now, the report also contains findings as to other states who we believe failed to meet their obligations fully under the Palermo Protocol, namely Cuba, Nepal, and to a lesser extent, Kazakhstan and Kenya. Kenya has made the most robust response to this problem. But we can maybe discuss that in the Q&A if you're interested in that. We also provide some key recommendations to states, which I'm happy to elaborate on later. But maybe I'll stop here and cede the floor back to you, Ina. Thank you.
Thank you, Ilya. I will pick up the floor for now to ask the question, to address the question to Dmytro. So Ilya just mentioned that indeed we started this research with this presumption that we're talking about the mercenaries issue, but then gradually we understood that the picture is more complicated. But still, now we're talking about, according to coordination headquarters for the treatment of the prisoners of war, like at least 30,000 people recruited from 130 countries, if I'm not mistaken. So, and there is a portion that was recruited through the human trafficking schemes, but there are still lots of mercenaries whom we can define probably as mercenaries or not. So my question to Dmytro would be like where this mercenarism ends and human trafficking victim starts, where like can we distinguish clearly those statuses? And like for me, as a non-lawyer, it sounds a little bit strange that the person who is participating in the Russian aggression against Ukraine can be considered simultaneously as a victim. So how is it even possible? And is it possible, do you think?
Thank you very much, Maria. And since it's the first time I'm taking the floor, thank you, Maria and Inna, for organizing this webinar. I think that we are touching upon a very important topic, not only for Ukraine, but globally. So let me start probably with saying that the issue, the problem of mercenarism was not from the very start of its regulation, was not seen as merely the IHL issue. So it from the outset included other kind of aspects of the problem of recruitment of foreigners to the armies of the states. It's true that the regulation as it stands in the additional Protocol 1 to the Geneva Convention from 1977 provides a very narrow definition of mercenarism, and basically the concern of the Article 47 of this protocol that defines mercenarism or mercenaries was created to satisfy the a narrower issue of foreigners' participation in the hostilities. But other international treaties that deal with mercenarism actually combine the kind of combat aspect of mercenarism together with other more kind of social human rights aspects of mercenarism. Take, for instance, the Convention of the Organization of African Union on the Elimination of Mercenarism in Africa. It's not just about the participation of mercenaries in the armed conflict, but also about other kind of phases of recruiting of mercenaries, but also about the whole phenomenon of mercenaries and how disruptive it is to the social fabrics of African states. The other convention of 1989, that deals with the recruitment, use, financing, and training of mercenaries, also even from its title, suggests that it's not only about the in war, in armed conflict aspect of mercenaries, but also about all the issues that we covered in the report, meaning the exploitation of vulnerabilities of social certain social strats or social groups. It's also about the whole business around this exploitation. It's also about the violation of human rights in the course of recruitment, etc., etc. So from the outset, the issue of mercenaries, the problem of mercenaries, is larger than just an IHL issue. Second point that I want to make in this regard is that IHL never works in vacuum. So it always requires other branches of law to reinforce it, to inform it. So there is no kind of legal lagunas when it comes to regulation of certain aspects of treatment of different groups of people. And this is true to when it comes to general international humanitarian law and international human rights law. There is good examples of international jurisprudence that states this, that international human rights law continues to apply when the armed conflict breaks down, and also it applies simultaneously with international humanitarian law. Of course, international humanitarian law is so-called, if we speak legalese, it's a lex specialis, so it's a special regulation that applies to the armed conflict, but it can work in vacuum in many aspects, and then international human rights law reinforces and informs it further. And it concerns not only international human rights law, it concerns other fields of law, like the law of the sea, for instance, which was made obvious by the arbitration between Ukraine and Russia when the ad hoc arbitration tribunal stated that law of the sea continues to apply despite the state of armed conflict between Ukraine and Russia. And it, of course, concerns also the international criminal law, sensu lato, or in wider sense of this word. The law that deals with the combat of international organized crime also applies in the situations of armed conflict, and it further informs the parties, the stakeholders, on how to protect human life and human rights better. So that's the introduction. I hope it was not too legalistic, but now I'm turning to kind of more direct entertainment of your question. And here I want to say that it's completely possible that one person can simultaneously be a victim of such a crime and participate in the violation of international law in other domain. Let me give you another example, so it's more illustrative. For instance, if the child is recruited to the armed forces, there is a crime of recruitment of child to the armed forces. That's the crime that is recognized by international community, and that's a violation of international humanitarian law. But at the same time, this same child can participate in the crimes, in the violations of international humanitarian law, or in the even war crimes. By participating in these war crimes, this same child becomes potentially a war criminal. Of course, there might be jurisdictional limitation either on the side of international tribunal or on the domestic side that would prevent the court to recognize such a person as a war criminal. But at the same time, after 18, for instance, there are mostly no limitations to recognizing the person who first was a victim of the abuse, then as a criminal him or herself. And as when it comes to international jurisprudence, there is a very prominent case in this regard, the case of Dominic Nguyen, who was recruited as a child soldier, but later participated and even commanded some of the war crimes that troops, forces under his command committed. So, turning back to mercenaries or the victims of human trafficking, and at the same time participants of Russian aggression against Ukraine, same logic applies. The person who could have been recruited with the coercion, with the use of different coercive practices, can be the victim of human trafficking, but at the same time, him or her participating in the aggression or participated in the war may also requalify this person from the different legal standpoint into the participant of illegal war, into perhaps mercenary, and into perhaps person that might have committed war crime. So these legal regimes, probably the conclusion after all these examples is that these legal regimes, the legal regime governing mercenaries, the legal regime governing human trafficking, the legal regime governing the use of force, the legal regime governing prisoners of war, they all overlap and they can't work and be understood in isolation. And that's something that we try to show in our report. We show that it's indeed the matter of we have to apply individual logic to each case. We have to carefully study what portions of law apply and how these different branches of law interact to inform the decision regarding each particular individual. Either this individual should be treated as prisoner of war because he was properly recruited and there was no human trafficking, and this person can be then exchanged to Russia, for instance, and some of Ukrainian prisoners of war may be returned, or this person should be evaluated from a little bit different standpoint and should be recognized as a victim from human trafficking, and therefore his or her return to Russia would be a very problematic issue from the human rights perspective, and therefore probably the better way out from this situation would be to negotiate with the state of origin of such a person on how this person can be returned to that state. So yeah, the short answer, it's not against the general logic, it's not against the how law applies in other spheres. It's just the reality that different regimes overlap and they work simultaneously.
Thank you, Dmitro, and thank you, Ilya, for your very interesting presentations. I have a lot of questions about follow-up questions to what you shared with us. Speaking of, I would like to invite our participants. If you have questions, you can start putting them in the chat box below, and we will try to address them during the Q&A session. And we will also take questions in Ukrainian if that is more convenient. And now I would like to invite Artur to the floor and to ask, what makes Russian recruitment efforts in Central Asia special, and what distinguishes the Central Asian states' reaction to their recruitment? Because actually some of the states like Kazakhstan prosecute the fighters themselves, but do they investigate the recruitment networks also? We can see lots of information about Central Asians, especially labor migrants, being forced into the service. Has it been investigated and considered by the Central Asian authorities from the human trafficking angle as well?
Thank you so much for the question, and thank you for the organizers of such event. I believe it's really important to speak about the issues that we got and actually about foreign fighters in Russian army too. So about Central Asia, it's I mean, Central Asia is not one country, and actually it's is made from different countries that have different understanding, and what's also important, different relations with Russian Federation and diplomacy. So actually about Kazakhstan, what I usually start my speech with is that when we were doing the report, the number of foreign fighters from Kazakhstan was about 1.5 thousand. And after we did it, the number became much more than 2,000 people. I mean, for such short periods of time, the number has grown about like 500 people. Actually, I also would like to thank the Office of Hachujik project, because their information is, I believe, a key basis for our, was and is the key basis for our job, and the job that we did, because they are showing a really good work on recognizing the people. And I believe that without their work, it was not possible for us to do anything. so about Kazakhstan, as I said, there is a different practices in Central Asia and in Kazakhstan too. If you can like see in the media, Kazakhstan always like trying to publish some small information about like the citizen of Kazakhstan was sentenced for being a part of international like a foreign armed conflict. But we see a lot of issues inside this practice. When we just started, and when I personally just was making researches about that, we saw a big amount of people who were joining like private military company Wagner, and they were getting back to Kazakhstan at this time. And we also had a one court decision for mercenaries. But in Kazakhstan, there is another norm in the criminal code that prohibits, that criminalize the participation in a foreign armed conflict, and that's one of really interesting stories because it is harder to prosecute the person for mercenarism because you have to follow the convention, you have to prove that the motivation was in the money, and the person fits all the convention required. But because of that, a lot of prosecutors was doing the work to prosecute person by participation in foreign armed conflict. That's why we analyzed about 20 court decision, 20 court sentenced for different categories of Kazakh citizens, and only one from 20 was for mercenarism, and 19 was for taking part, like participation in the foreign armed conflict. I believe it shows that sometimes praxis in prosecutors are going to the easiest way, but not to go, to go deeply and to understand what the person does, how he was recruited also, and what happened to him. Actually, Russia spends a lot of a lot of budgets and big budgets for recruiting people in Central Asia. We believe it happening for a few reasons. Because first of all, Central Asia countries, they still got compulsory military service for the most part of population and for men too. That's why, like recruiters from these countries, they have, some basic knowledges of how army works, how I don't know, like to handle with a gun and stuff like this. Plus, there is less problems with language barriers. That's why we believe also that Central Asia countries is one of the aims for recruiters. And secondly, as we talked before, there are a lot of labor migrants from Central Asia inside Russia nowadays. So they don't have to spend more time to transport them from another countries. They are actually in Russia now. And that's why they are using, the ways to recruit them with involving police, some kind of prosecution, and anything like this. By the way, like Kazakhstan is doing, at least we got 70 court sentence for such people. Actually, there are more. 20 is only the number that we were able to find. If we do compare it to other countries, we see that only Tajikistan have a really strange position that we have never heard about any criminal prosecution for people who was in a Russian army, who was participate into invasion to Ukraine. We don't know exactly for what reason it is, but if we don't see a legal reason, we could say that it is made of some political decision that Tajik government, they don't want to rise up such issues, and they don't want to do anything because they actually have the same legal frameworks as Kazakhstan does and other Central Asia countries. What is extremely interesting for me now is that Kazakhstan is now like recently there have been proposals from Kazakh authorities to soften criminal liability for citizens who participated in foreign armed conflicts. And it says like they were, and the argument is that many people join such conflicts because of difficult life circumstances rather than criminal intent. It's really strange for me, and as I mentioned at the beginning of my speech, the number is still growing. That's why the humanitarian concerns behind this proposal, I don't believe that this will reduce, that reducing of punishment will reduce the number of people who are getting involved. It's not the right solution. I really still believe that the right solution is to have a program and to have a strategy to prevent such crimes. I mean, if your citizens are not joining the Russian army, that is the best option, and you don't have to do a lot of things. But we don't see that Central Asian governments are trying to build such strategies. When we've been making the report, we've sent a lot of like official requests to authorities, to General Prosecutor's Office, to special services, to Ministry of Foreign Affairs, asking them like, okay, there is a problem. Like thousands of people are joining Russian army. Some of them are going back to home countries, homeland, and they are getting prosecuted. Okay, but do we have a plan how to prevent this? And what's the number of people, and what are you doing to stop this? Unfortunately, authorities were unable to provide clear statistic on the number of criminal cases specifically linked to participation in this conflict. They also did not present any prevention strategy, any structured policy framework, or evidence of systematic interagency coordination. So that's still the biggest issue that we want to raise up, and we get such recommendations in the report, and that's why I believe like Central Asian governments should work more about this issue, probably with help of Ukrainian government too, and other countries.
Thank you so much, Artur. So you started this overview of the reactions of the government, and I would like to proceed with the African continent, understanding, of course, that Africa is not a country as well, as the title of the famous book speaks. And I would like to turn here to Rosemary Tolo, because Rosemary follows those reactions of the different states, and in particular Kenya, of course, but not only. And in some of the cases, we have seen the very active reaction, as Ilya was also referring to, in Kenyan case, right? So we have the president, the parliament, the media, the civil society. Then we have also more or less active reactions in countries like Ghana or South African Republic. But how would you assess it overall? Like whether this reaction was sufficient with these states, but also some other states? Like for instance, Sahel region. We don't have much time to dive into that, but that would be a usual suspect. You know, we would expect that we would have lots of people coming from that region, but we can't see like this trend. And it would be interesting to know like why is it so. And maybe it will be also highlighted in your upcoming report. I would like also to you, Rosemary, to tell us a little bit about the report that you're going to present on June 7th, right? So you will be launching the report specifically on African countries. What do we expect from this report? I know it will be important investigation that you've done.
Thank you, Maria, and thank you for putting this together. So first of all, I'd like to say that the reaction from African states has been important, but it has been late, uneven, and in many cases driven more by public pressure than by proactive government action. So Kenya is a really good example. For a long time, there was some kind of an easy silence. In March 2024, when Russia claimed that some Kenyans were fighting for Ukraine, Kenya dismissed that allegation. and reaffirmed it does not support mercenary activity in any form. At that time, there was no clear public proof that at the time that Kenyans were serving in the Russian military. But then evidence began to pile up. It started with videos and images on social media of young Kenyan men in Russian military uniforms. There were messages from families. There were returnees coming back quietly from Moscow, in some cases needing medical attention. And then there were mothers and wives going to government offices in Kenya with desperate questions. Is my son alive? Is he dead? Is he in prison in Ukraine? Who recruited him? So the pressure did not start from the state. It started from media and families. Eventually, that pressure became impossible to ignore, especially when a Kenyan athlete was captured by Ukrainian forces in September 2025. On 27th October last year, Kenya's Ministry of Foreign Affairs issued a warning. It said young Kenyans had been lured into Russia by corrupt and ruthless agents using false documents and fake job promises only to end up in Russian military camps. That statement did not call it human trafficking, but legally, the description was very close to trafficking. Recruitment by deception, movement across borders, exploitation, and loss of control. Then on 6th November, the Kenyan president spoke with President Zelensky and raised the issue of Kenyans illegally recruited into Russian units. That was important because the issue had moved from family distress to the highest levels of diplomacy. Now, pressure inside Kenya continued to grow. On 12th February this year, the Speaker of the National Assembly urged the government to issue an immediate public advisory warning Kenyans there are no legitimate job opportunities in Russia and that such offers are front for recruitment into a war zone. That same month, affected families were also protesting in Kenya, demanding answers about their missing relatives and calling on the government to act. More recently, there's been a petition to Parliament. The affected families have been invited to make a presentation before one of the committees on 9th of June. Now, this is significant because it moves from the issue, moves the issue from private grief and media reporting into an official accountability process. So yes, there's been movement. But I would still say the response is not sufficient. There is a catch-22. African countries want to maintain friendly relations with everybody, with Ukraine and with Russia. So you end up with statements such as this one from the Kenyan foreign minister. We don't want our relationship to be defined by this war. Relationship is far broader. That captures the central weakness in the African response. Many governments are treating this mainly as a diplomatic problem. You see the same caution everywhere. In Ghana, the foreign ministry described the issue as youth enlistment after a technical session with Russia. In South Africa, after some nationals were returned, the government expressed heartfelt gratitude to Russia. Now, of course, diplomacy matters. States have to manage relationships, but for the families, that kind of language can feel very inadequate. Their sons are dead, missing, captured, or still on the front line. So when governments speak mainly in diplomatic terms, it sounds as if the relationship with Russia is being protected more than the citizens themselves. By contrast, of course, African states have not been as definitive as India. From my reading, India has been much clearer and more direct. Prime Minister Modi raised the issue directly with President Putin, and India has repeatedly demanded the release and return of its citizens from the Russian army. Indian officials have also warned citizens to stay away from offers to join the Russian military. Now, that comparison matters. India also has an important relationship with Russia. So this is not simply about whether a country has diplomatic ties with Moscow. The difference is that India has been more willing to publicly frame the recruitment of its citizens as a matter requiring urgent state intervention. Okay, so you look around, African governments, again, and I repeat, by contrast, have often used softer language, right? Irregular conscription, agents, while avoiding a more direct public demand that Russia stop recruiting their citizens. and release those already enlisted. Of course, you have to talk about some concrete developments, positive in some cases. For example, Kenya has reportedly secured a commitment from Russia that Kenyan nationals will no longer be enlisted through the Ministry of Defense. Ghana has reached an agreement with Kyiv for the repatriation of its prisoners of war from Ukraine. Zimbabwe has sought the repatriation of bodies of those killed from Russia. Egypt, however, has taken a more punitive approach by revoking the citizenship of at least some of its recruits. But this, again, remain fragmented national responses. What is missing is a coordinated African position. As of May 2026, which is just last month, the African Union had not issued a strong statement or resolution on the recruitment of Africans into the Russian military. The silence is striking, especially when Ukrainian officials have said that thousands of foreign fighters have been recruited into Russian forces, including significant numbers from Africa. And I think the more are expected in the coming season. So this is not a Kenyan problem, it's a continental problem. In my view, 4 things are still lacking. First, there should be clearer public warnings. Many African countries have laws against foreign enlistment, but governments have not even talked about it, has not consistently warned citizens that joining a foreign army may be illegal and could expose them to prosecution. Then we need proper investigations. This is not simply a matter of individual men buying tickets and traveling to Moscow. In many cases, there were agencies, intermediaries, payments, contracts, handlers. That network needs to be investigated. Then there is the protection for survivors and families. Some of these men may return home only to face prosecution, even where there is evidence that they were deceived and trafficked, coerced, or placed in situations they did not fully understand. So governments need to distinguish between recruiters, facilitators, and vulnerable recruits. And finally, there needs to be a continental response, as I said, a coordinated position. Now, on the report we are about to publish, I would say this. As far as I know, it will be one of the first major investigative reports from the continent looking at this issue from an African accountability perspective. There has been important media coverage, but much of the public conversation has relied on isolated cases, government statements, scattered press reports. What we are trying to do is different. We are documenting the pipeline. In other words, we are asking a young man move from employment in Kenya, Ghana, South Africa, or another African country into Russia's war. The Kenyan case study is especially detailed. We have traced specific cohorts, payments, agencies, travel routes, and the experiences of men who are captured or reported missing. Okay, the report also looks at the law. Kenyan law treats deception-based recruitment as human trafficking. And a recent Kenyan court decision in a trafficking case involving Myanmar strengthened the argument that deception that begins in Kenya can trigger Kenyan jurisdiction, even if the exploitation takes place abroad. Now, that is very important for families, mainly because it means they have legal avenues, not only against recruiters, but also potentially against state failures to protect. Now, our report asks a simple question: how was this possible? And our answer is that this happened because of several overlapping failures: unemployment, weak labor migration oversight, poor enforcement of foreign enlistment laws, diplomatic caution, and Russia's urgent need for manpower in the war. So for us, this report is about documentation, evidence preservation, and accountability, but it is also about the families. Many of them still do not know whether their sons are alive, dead, captured, or still fighting. So to summarize, African governments have started to react, but they have not yet responded at the level of the harm. Thank you.
Thank you, Rosemary. I have an immediate follow-up question based on what you mentioned, but also based on what we've heard so far. These findings summarize the situation we knew about, we read about on the news, but now we have legal, analytical findings to show that Russian practice of recruitment of foreign nationals to join their forces by deceit or directly has place. It will continue. We understand that it will only increase over time. what can we do as lawyers, as an international community? What other accountability or advocacy avenues we can use to maybe create more pressure on Russia? Do these findings open any additional doors that we can actually use in this situation? And it's a question to I suppose everyone, whoever's would be courageous enough or just would like to share their thoughts on this.
So thank you. I'll stick to my lane and speak to the media aspect. I'll let the lawyers respond to the legal stuff. I think information is power. What is clear is that all this came to light because there was a lot of response, public and written. We had lots of visuals. We had a lot of written reports. We had coordination between families and media. And in my view, the more we write about it, the more we expose networks, the more information families receive and understand, as well as the young people. For example, it is clear that we have, according to according to ILO, we have a continent full of young men, the youth, who are willing candidates. We have, I think, 13.2 million young people who are not in education, not in training, and they're all ready and willing to travel to Russia. Not because, it's about survival. So in my view, there's need for more information. There's need for more coordination between governments, civil society, as well as the media.
Thank you so much. Dmitro, Ilya, would you like to add from the legal point of view on accountability mechanism? Is there mechanisms? Is there anything else we can do based on your report? Or maybe you as organizations plan to plan any follow-up steps with the report in terms of triggering accountability, a more accountability response?
Well, if I may, I am certainly happy to start the conversation on this. Yes, sure. So we think that, of course, to the extent that there are indications that individuals are joining the war on Russia's side, motivated primarily by financial gain, and they're violating the internal provisions of the domestic law of the states of origin. Those states should prosecute those individuals for mercenarism offenses or for participation in foreign armed conflict. Now, there's one question already in the chat that asks, well, how do these individuals qualify as mercenaries if they're members of the armed forces? This is very true and a very valid question. And under international law of mercenarism, if you will, in the UN Mercenarism Convention and Article 47 of AP1, as Dmitro has said, the definition, the elements are quite extensive and the definition is very narrow. So it's very difficult to meet those criteria under international law. But of course, many states define mercenarism much broader. And this is one problem we identify, is that there is actually a disconnect between the legal definition on the international level and on in the legal definition in the individual on the state level. And so there is, if you will, yes, a mismatch between state practice and international law, which needs to be rectified. And so that the law has to be adjusted to match that state practice. We actually give some indications on how states can read the requirements of Article 47 a little bit broader than what is suggested in the language of that law itself. For instance, and which would allow also, let's face it, because Ukrainians are also using foreign fighters. So we're not blind, and we don't want states prosecuting foreigners who are fighting on Ukrainian side for mercenarism. But I think the way Russia is doing is much different than the way that Ukrainians are doing it. And for instance, the way that Russia is integrating these soldiers in its armed forces, it really isn't. What it's making people do is sign a piece of paper. There's actually no training, no explanation of what the individual is signing. So for all intents and purposes, we're suggesting that they don't become members of Russia's armed forces. And this gives, I think, states, and including Ukraine, additional ammunition to argue that these are, in fact, mercenaries on Russia's side because they're not members of Russia's armed forces. They're not fully integrated. They're not fighting as a collective unit. They're not trained, and they don't obey by rules of international humanitarian law. So they could be treated as mercenaries under the broader international law framework. But states are still should go after them on domestic level. But so the stronger tool, legal tool, we believe, is the Palermo Protocol, because this is much more widely ratified instrument, almost universally ratified. This is why we make such an emphasis on this instrument, because otherwise the legal framework governing the use of foreign fighters is really fragmented, and there are gaps. But the Palermo Protocol, to the extent that there is evidence of coercion and deceit, gives states the obligation. It requires ratifying states to investigate and to dismantle the recruitment networks, to prosecute recruiters, and to adopt measures that will prevent recruitment. So we will insist, and we have been insisting in our advocacy, that states of origin, but also states of transfer of foreign fighters, do everything possible to conduct effective investigations of these networks of recruiters or individual recruiters and prosecute them, but also conduct educational activities and so on. And since we touch on this legal aspect, it's important to note that the Palermo Protocol contains a compromissory clause that requires states that have divergent interpretations of the Palermo Protocol to take their dispute to the International Court of Justice. We are quite adamant that states that have seen their citizens used and abused by the Russian Federation in the war of aggression against Ukraine voice their concerns with Russia with the view towards taking this dispute to the International Court of Justice should Russia not agree to repatriate the citizens, stop the recruitment, and provide reparations. Why not Kenya take Russia to the International Court of Justice? We've seen the Gambia take Myanmar, right, to the ICJ. We've seen South Africa take Israel. So there's precedent there of African states going after more powerful states in legal fora. This is a growing is on the rise, and we think that this is one avenue to explore.
Maybe I will add just a couple of quick points to what Ilya said. First of all, I back all the things that Ilya voiced, but maybe in addition to that, I just want to mention that there are three slightly different definitions of mercenaries in three different international treaties that I named previously. It's AP1, it's Global Convention Against Mercenaries, and the Organization of African Union Convention. But all three definitions have this provision saying that mercenaries are those who are not integrated into the armed forces. However, if we look deeper into this clause, we'll see that why this clause even appeared in the AP1 and then in the African Convention. It's because there was a practice, significant practice by 1977 of states using foreigners in their armed forces, and these foreigners were integrated into the so-called foreign legions. Usually it was called foreign legions, but it could have had different names, of course. And these kind of units of foreigners foreigners were the natural part of the armed forces of the states. So what the states wanted to achieve through this clause is to kind of prevent anyone from saying that these foreign legions are mercenaries just because of their nationality. So that's how this clause was read, at least during the negotiations towards the signing of AP1. So now what we are seeing with Russia is that through kind of signing pro forma contracts, which are very often not translated even to not even the language of the recruits, but even to English, we see that Russia tries to circumvent this provision of the AP1 and tries to basically reinterpret it so it covers all the instances of even formal, very superficial integration of people into the army. So that's what brought us to the idea that we should we should consider, of course, the AP1 definition as something that states were able to agree upon, but also we should understand the modern realities of how the recruitment works and what are the vulnerabilities that are being exploited and how the states develop the strategies to creatively apply, so to speak, their recruitment tactics so they do not fall under the provisions of either AP1 or other international treaties. And for that reason, I again back what Ilya was saying, that we don't think that in all the cases of formal integration we can speak about actual integration and so fulfillment of the provision set forth in Article 47 of the Additional Protocol 1. But again, that's only one way to do it. The other way to do it is to go for a Palermo Protocol. And I think that using Palermo Protocol will show that Russia falls short of not violating rights not only of individuals, not only in Ukraine, but also worldwide. And also it shows this quite an imperial logic, I would have to say, of exploitation of vulnerabilities in lots of places in the world, especially in Central Asia, Southeast Asia, and Africa. So that would be my answer to the question, Ina.
Thank you so much, colleagues, for these answers. And we have the question about prisoners of war, and that's one of the issues that we would also like to discuss within this webinar. Although I realize that it's very complicated, it requires the case-by-case approach, obviously. But still, let's discuss it at least in general. So there is a question about whether there is some whether countries of origin try to contact Ukraine and repatriate their citizens taken as prisoners of war in Ukraine. We're not getting those requests. So this is the state, of course, that is getting them. But obviously there are these requests, and they're being sound also publicly, and they're made also not in public. But I would like to ask our panelists about prisoners of war that are not requested by Russia and that stay in Ukrainian prisoners of war camps. And there is kind of public and non-public debates within various institutions and in the expert community about what are the solutions for this matter, because obviously if they're not requested by Russia within the swaps, what should Ukraine do with them? Should Ukraine keep them like forever? Or there are some other options how Ukraine can transfer them to their home countries, for instance, although in the conversation with the coordination headquarters for the treatment of prisoners of war, they would say that current legal framework does not allow Ukraine even consider this option, and that nobody would take this political responsibility of transferring any foreigners or prisoners of war, like belong to Russian army, back to their home countries. So what's your take on that? So are there any solutions in the IHL already? Maybe you're aware of some of the precedents in that regard. How you think this issue can and should be resolved further? Who would like to comment? Artur, would you like to, because you missed the second round, maybe you would like to start.
Thank you, Maria. I've been asking this question to myself, I believe, since 2023, when we saw the first prisoners of war from Kazakhstan in Ukraine. And I really believe that if the citizen of the country is a prisoner of war in Ukraine, the country should take care of these people. I mean, I clearly understand that, for example, Ukraine now, they don't have a possibility to, do some trading, to do exchange about these people. But as I understand by Geneva Conventions, there is a possibility to have an agreement to hold these people on the third country by the agreements of conflict states. And that could be one of the options for this. So, for example, if like a country like a Kazakhstan or whoever else is saying that we are ready to keep these people on the territory of Kazakhstan and waiting for the decision from Ukraine, yeah, that is one of the options. I really believe in that. But we see that not every country is okay, and I haven't seen any public decisions from countries to do like this. And maybe that's a place to think about it. So if you're gonna keep them as a prisoners of war, but in a territory of the third country, that could be nice. And plus, after the war will be ended, you have to leave them all, and they could be prosecuted by their countries too, because like, okay, the guy, the citizen of Kazakhstan is a POV on the territory of Kazakhstan by the agreement, by international agreement with Ukraine. Then the war ends, he has to be leaved and then prosecuted for being for participation in a foreign armed conflict. That was only my idea. I haven't heard that seriously from different sources. But why not? I think countries could take care, because I clearly understand that Ukrainian government has to spend the money to keep the prisoners of war. Ukraine has a lot of problems now, and I believe that it could be one of ways how to solve this problem. Maybe colleagues would add something too.
Thank you so much, Ilya. So we discussed this issue a little bit within the preparation of the report. What would be your answer to this question?
Well, I can tell you the response that we kind of came up with, because if you look at the legal frameworks and what international humanitarian law says that one should do, one should repatriate a POW to the country on which they depend at the conclusion of hostilities. So if we go by the book, then the POWs that were captured by Ukraine that basically fought on Russia's side should be repatriated to Russia, the country on which they depend, at the conclusion of hostilities. Now, we also say that because some of these individuals might be victims of human trafficking, that Ukraine should look into this issue. And then we sort of suggest that with respect to those individuals, then the law on human trafficking should apply as lex specialis to lex specialis, if you will, and that they should be then repatriated more quickly, as soon as possible, to their state of origin. But then and we do believe that IHL does permit that, because then the second paragraph of Article 118 that deals with the prisoners of war issues does provide for the possibility to enter into agreements, special agreements regulating the transfer of POWs between the parties to the armed conflict. But we also think that they can be concluded with third states, and then the agreements could be made, say, with Kazakhstan, to ensure that they're repatriated to Kazakhstan. But then, we see the obvious problem with that is that Ukraine doesn't get its prisoners of war back in return, and this is the where politics sort of meets law and conflicts with law. How to deal with this issue? Well, there should be some kind of tripartite agreements whereby Ukrainian POWs then come back to Ukraine, and those held by Ukraine go back to the country of origin. But then will Russia agree to that? That's already a different question. I don't know what Dmitro thinks about this.
I also do not have the answer to this dilemma, the dilemma that you framed, law meeting the politics. But I would maybe want to a little bit rephrase this, because it's not only about politics; it's also about human rights of Ukrainians, for which Ukraine is responsible actually, and Ukraine is responsible for trying its best to return Ukrainian prisoners of war from Russia. And in this sense, returning prisoners of war to or foreigners to the country of their origin may contradict or come into conflict with the obligation of Ukraine to preserve the rights of Ukrainian prisoners of war. This being said, I'm not against the idea. I don't see other ways, frankly, than tripartite agreements and some arrangements that would motivate Russia somehow to return prisoners of war, but at the same time that would not get people who were recruited with the deception, with the use of deception, to Russia, but rather to the countries of their origin. Also, what we learned working on this report, I think, is that it's again quite an individual approach should be used when the policy towards foreign fighters is drafted, because there are some foreigners, let's face it, who want to return to Russia. And in these cases, I think it's more of the Ukrainian decision to make whether it wants to return these foreigners to Russia and get back its prisoners of war, or it should work with the other countries. Again, I understand that sometimes they want to return to Russia because of the coercive practice used against them before, or because of, for instance, a fear that their families won't receive any money that they invested into the whole recruitment chain to even get for these foreigners to even get to the war. I understand this, and again, on the individual basis, these cases should be investigated. But also, we should not disqualify fully the idea of returning some persons to Russia if there is no kind of signs of deception on the phase of recruitment, and if there is a desire, and if there is a chance to get Ukrainian prisoners of war from Russia. So that would be my small addition to what Ilya said.
Thank you, Dmytro. Rosemary, would you like to add anything on this question?
Thank you, Maria. Maybe I'll say what I'm hearing from the field, from the families in Kenya, and from some of the African countries. So first, it's a difficult issue because Ukraine is dealing with people who are captured in Russian uniform. And so when you find who are, of course, not Russian nationals, and when you speak to the families, a lot of them keep on asking, why can't Ukraine just return them? And they face the music at home. I mean, that's basically what they're saying. So I'm telling you what the families think and feel. But the first point is this: Ukraine is right to treat them humanely and to give them prisoner of war protections where applicable. And that's very important. It means they're registered, fed, protected, visited, and not treated as people without rights. But I think there's need for a specific strategy for third country detainees. Now, the problem is, if you treat them like ordinary POWs, then you return them to Russia, they're going back to the battlefield. Right. And I mean, because we've had things about contracts that need to be fulfilled. So return them and they're going back to the battlefield. And they're being used as cannon fodder, which also defeats the purpose of getting them out of the conflict, because Russia, of course, will use them in whatever condition they're in to try and advance their territory. So you have to face the facts. And Ilya is talking about the legal mechanisms, but now I'm talking about what people are hearing, seeing, and feeling. Then, of course, there's the fact that, there's some, who obviously committed a war crime, and that must be investigated. But then, of course, the issue is, the legal question should not only be, did this person fight? It should also be, how did he get there? In practical terms, Ukraine should not simply ask, can this person be exchanged? Then, of course, there's a strategic advantage. If Ukraine documents these cases properly and works directly with African governments, it can expose Russia's recruitment practices more clearly. It can also show that Russia is, exploiting poverty, unemployment, weak migration systems across the global south. So the issue is not to release everyone blindly. That's not what I'm saying. And it's not to exchange everyone back to Russia automatically. I think the approach would be to protect Ukraine legally, but also protect potential victims and preserve evidence. And of course, put pressure on the governments whose citizens have been pulled into this war.
Inna, would you like to?
Yeah, thank you so much. I would like to ask another question, maybe going back to accountability in the against the background related to the establishment of the special tribunal for the crime of aggression in Ukraine, which we advocated for and hope that it will be operationalized in the nearest future. I'm wondering, I hope that there will be a comprehensive umbrella of accountability in place, especially aimed at senior political and military commanders in a position to make decisions. And I'm wondering if engagement of mercenaries, foreign fighters, especially based in deceit and using vulnerable nationals in other countries. I'm wondering whether this practice could somehow contribute to the review of the crime of aggression by the special tribunal when it is established. It's a stretch, but I would be grateful for your thoughts on this, whether we can this phenomenon could somehow strengthen the case of the crime of aggression.
If nobody objects, I can start addressing this question. So the only obvious scenario in which the country of origin of the foreign fighters can be somehow, or rather the leadership of the country can be somehow prosecuted, investigated and prosecuted in the special tribunal of the crime of aggression is when there is an institutional support of Russian war efforts. And this institutional support we see only in case of North Korea so far. In other scenarios, it's much harder to build the case saying that the either the leadership of the country or the recruiters or whoever else really contributed to the aggression and that they were participated in shaping or influencing, if we use the lower bar of the policy of Russian state to engage in aggression against Ukraine. So I would say that with North Korea, it's more obvious, with others, less obvious. But apart from this legal aspect, there is also an advocacy aspect, and perhaps showing the countries how Russia, what predatory practices Russia uses to recruit their citizens to strengthen its war efforts may bring these countries closer to some sort of supporting of the special tribunal. This support may be in a form of joining the agreement on establishment, so-called enlarged partial agreement on the establishment of the tribunal. It may be also in the form of some associated partnership with the tribunal. That would not mean much for the country, but that would symbolically be important for Ukraine and will show for Ukraine that the special tribunal is not something that was created only to deal with this war, but also something that sets a precedent that may be used in other contexts, including in Africa or elsewhere in the world. So I think that legal and advocacy aspects are quite different, but both of them are important, and perhaps we should include the talks about foreign fighters in the broader campaign to advertise a special tribunal worldwide.
Thank you, Dmitro, and that's exactly my thinking and a wonderful message to voice closer to the end of the webinar. We advocate for a wider wider circles of countries joining the enlarged partial agreement, especially countries of Global South, whose support of this endeavor is crucially important for not only legitimacy but also effectiveness of the tribunal, and for positioning the crime of aggression as indeed a key crime that needs to be addressed. I don't see any other questions in the chat from our participants. I think we may have exhausted the questions we had so far. However, I'm sure, and I hope the discussion will continue, and there will be more and more support to the effort and advocacy related to dissemination of the results of the findings of your report, all the reports we mentioned today. And then this will create more additional pressure on the Russian Federation. Maria, would you like to say a few words before we close the event?
Yes, thank you so much. I would like to thank to all of the panelists for the great interventions and great statements and great ideas. I would like to say for those interested that you can read this report on the on the website of Truth Hounds or FIDH. So it's available in English, in Ukrainian, and the executive summary is available in French and Spanish, in Russian, I guess, language. So please go ahead and read it. And just to say that whilst in some countries this recruitment process is almost halted, like for instance Nepal, by the way, but in other countries get more targeted. For instance, now Peru is an absolute leader, unfortunately. So we got even like in my message box, I got requests from lawyers, from family members, asking to advise how they can return their family members from the Russian army, from the front lines, which is like really hard question to answer, to be honest, when they're already in the Russian army or in the front lines. So this is not unfortunately the end of the story. There is a predictions that Russia would recruit this year only more than 18,000 foreigners to the army. So they're still exploring the ways of doing that, and we will be watching this, and we will be following up on this, and we will try, of course, to advocate for this process to stop. Thank you.
Thank you, Maria. From my side, I would also like to thank our outstanding speakers today, and Maria, you for organizing and moderating today's discussion. And we are particularly grateful to our institutional partners who joined today's and the series of webinars on transitional justice in general. I would like to invite everyone to stay tuned, subscribe to our events, because there will be more events dedicated to transitional justice coming up, as I've mentioned, and we would be very grateful for wider dissemination of the information about the events and analytical work that we will continue to share. Thank you to everyone. I wish us a very safe and quiet a day, afternoon, wherever you are. Yes, Maria, I see your hand. Please go ahead. No, okay.
I wanted to signal thank you, but yeah, that was wrong button.
Thank you a lot to everyone. Thank you to all the participants who joined us today and stayed with us, and for your questions as well. Please stay tuned, stay in touch, and until we see you soon. Bye.
Thank you.
Thank you. Bye.
Be
Thank
safe.
you, Ina. Thank you so much.
Bye. Thank you, guys.